you started getting into this, but just in terms of why it's running into the seven figures, what makes it challenging to comply with a second request? Would love to hear a bit more about that.
Yeah, absolutely. So, we typically, the number of, what we call custodians, the scope of the request, the agencies want to see emails, internal documents from a number of individuals within the corporation. So typically that number can range anywhere from basically 15 custodians, if it's a small investigation, to, upwards of 70, sometimes even 100, if there's a lot of different overlapping areas and different business segments that are involved. This would require the collection of, sometimes millions of documents, and then the review and production of those documents. So we've started, ever since I started running second requests, my goal has always been to try to make it more efficient for my client, and because then everyone wins. These transactions, when there's a merger pending, time is of the essence. You need to close that transaction as quickly as possible. And you don't have time to waste. And in addition, having attorneys sit in a warehouse, having hundreds of contract attorneys sit in a warehouse and review documents is inefficient, expensive, and frankly inaccurate. So I've tried to figure out what kind of technology can be harnessed to make the process more efficient. And, so the review comes into two parts. One, determining what is actually responsive of what you've collected to produce to the government. And then the second part is privilege. So of the documents that you've determined are responsive, what documents do you have to withhold from production because of the attorney-client privilege that you don't want to waive? So we have, back in 2012 was the first time that I started using predictive coding. And that's been a good tool to be able to determine what is responsive and what is not responsive. And it's particularly effective in second requests because of the broad nature of the categories of responsiveness. You're not looking for a needle in a haystack when you're responding to a second request. And so for that, predictive coding, which is essentially, a pretty basic algorithm that attorneys train through review to determine what's responsive, works well, and has proven to be more accurate than having a linear review where you have attorneys reviewing every document. And as you can imagine, is far more efficient and less costly. The problem, though, is that predictive coding isn't a good solution for privilege. I've tried to use predictive coding to try to predict privilege, but privilege isn't necessarily captured just by the four corners of the document, the content that's within the four corners of the document. And that's where predictive coding works well. For what drives privilege primarily is the relationships of the people and the roles that those people play in an organization. So there may be, certain business personnel who are very involved in privileged communications, but they might not be on your attorney's names list. And I have yet to work on a case in which I've had a perfect attorney's names list that's allowed me to create a perfect, search term safety net. The other problem with, trying to identify privilege is not only is predictive coding not effective, but search terms have a number of failings, primarily that it casts a net that is either far too wide, so you're pulling in a lot of documents that are not indeed privileged that increase the cost and time of your review. But then you also are potentially missing a lot. So, like I mentioned earlier, those individuals who might not be attorneys, but yet are very involved in discussing privileged communications. So I was in search of a better solution for privilege. It was something that was truly a pain point in the process. And the one area that I felt, I didn't have a good technological solution to. And Omar, actually, I was speaking about this exact pain point when we first met. So I was at a conference on a panel mentioning exactly what I just said. And then we met shortly thereafter, and you presented to me what TextIQ could do. And I remember saying, if you could actually do what you say you can, this is going to be game changing. And we were able to pilot your technology, and you could do what you said you did. So your technology has helped me be able to efficiently identify privilege in a way that's far more precise, that reduces the risk of missing privileged documents and also increases our efficiency by reducing those false positives, which then means I'm not wasting time and money on contract attorney review trying to understand what indeed is privileged.
Just thinking about, you mentioned time is of the essence with second request, and how, historically some of the discovery technologies like predictive coding weren't necessarily designed for privilege review, which can be very slow. But just like, how do you think about that trade-off between risk and time or cost, where, to some extent there may be a trade-off, but you obviously as an attorney are probably constantly balancing some of those issues.
Right. Well, I think so. Addressing the risk issue, that's someplace where I think that there is sometimes can be a misperception that technology and choosing a more efficient process means that it's a riskier process, or that if you don't have eyeballs in every document, that you're somehow missing something. And I tend to disagree with that. There have been a number of studies that have shown that the use of technology, both predictive coding for responsiveness and then, text IQ for, capturing what is actually privileged, tends to be more accurate than if you have a very large team of contract attorneys reviewing documents page by page, because of human error. Human error, just think about it. If you're sitting in front of a computer for, 8+ hours a day, day after day, and all your job is to look through documents, unfortunately, the people looking through the documents aren't as invested in the case as perhaps your core substantive team might be. And so to the extent that you could use technology that has, and you ensure that you do your statistical sampling, you ensure that you do your tests to ensure that you are getting the results that you need, that has proven study after study to be far more accurate and reduce your risk than if you were actually going through page by page with human attorneys reviewing those documents. And that's just human nature, unfortunately. Machines are better. And so, so that's one thing. And going back to privilege, again, using technology like Text IQ, it has reduced our risk because we've been able to identify documents that we otherwise would not have captured. Because we had, with our initial attorney's names list or our initial case assessment, we had no idea that that project name was something that was highly privileged. We had no idea that that business person was someone who is integrally involved in privileged communications. We had no idea that that business person was then forwarding on legal communications that otherwise didn't have any indication of privilege. So those are the types of communications that using technology allows us to capture and reduce our risk in a way that, again, alternatives, human review search terms wouldn't really do.
Ausra, when someone talks to you, it sounds like, or one might get the impression that every antitrust lawyer is using technology and familiar with it. But, would just love to hear a little bit, because it does seem like today, probably from an industry-wide standpoint, right, the process for most second requests that most law firms are following is fairly manual in nature. And so, can you just talk a little bit about what led you to really seek out technology kind of in the first place and become so familiar with these different kind of solutions that are out there?
Sure. So I challenge the status quo. It's what I do when I think that the status quo is not optimal. It's part of my nature. And when I was sworn in as an attorney, I took an oath to take on the cares and concerns of my clients as my own. So when I was confronted with the traditional way of doing a second request, and that would require expensive outside counsel, several associates sitting in a warehouse somewhere remote, overseeing an army of 300 contract attorneys, I just looked at that and saw the bills and saw the time and saw the total cost of that. it was overwhelming. And I realized that just could not be the way, that is not the most efficient way to be able to handle this. And the thing is that I think it's really important. A lot of places seem to discount the process or the need to have antitrust subject matter experts who actually pay attention to these process aspects and to the technology. And so I feel there's a lot of people who might scoff at, antitrust attorneys, substantive antitrust attorneys who get so involved in the process as I do. I disagree. I feel that it's really important because the two aspects are so intertwined. Timing of these transactions is crucial. So anything that you can do to speed that along is going to be helpful to the clients. The other thing is that the more involved that you are in the actual process and understand that process, the more insight you have into the company to understand who it is who you could turn to get the dispositive facts that you need to present substantive, compelling advocacy to resolve the issues. Antitrust is all about the facts. It's all about the competitive dynamics. And you need to be able to understand where those facts are, what they are, and who you can talk to get those. So being involved in that process allows you to do that and to also be able to identify those facts more quickly. And so I turned to technology because, I didn't have the patience to wait 6 months for an army of contract attorneys to review documents before I could start to really be able to understand and find those facts and be able to apply those in the most compelling and efficient way for the clients to get them the substantive wins that they need.
Thanks again for your time, and thank you so much for dialing in today.